Welcome to CARICOMP Insider, where high-tech facial recognition meets real-world intelligence.
A private letter from Apple nearly wiped one of the biggest AI apps off every iPhone on the planet. Not a court order, not a new law, a letter from a company that controls a digital storefront. If you've ever downloaded an app, this story is about the invisible gate between what AI can do and what actually reaches your phone. In January, the social platform X was flooded with AI-generated pornographic images made without consent, some involving minors. The tool that created them was Grok, built by Elon Musk's company xAI. California's Attorney General opened an investigation. Lawmakers held hearings. But the thing that actually forced xAI to change its software wasn't any of that. It was Apple privately telling xAI that Grok would be pulled from the App Store unless it fixed the problem. And xAI fixed it. So who's really policing AI? Elected officials, or the companies that control where you get your apps? Apple's review team found that Grok violated App Store guidelines by letting users generate sexualized deepfakes of real people. Apple rejected the app. The xAI submitted fixes. Apple reviewed them again and determined the safeguards were, in their words, substantially improved. The app went back up. That entire cycle, rejection, negotiation, technical fix, reapproval, happened faster than any legislature could draft a bill, let alone vote on one. Meanwhile, the Tech Transparency Project went looking at what else was sitting in those same app stores. They found 18 apps with nudifying capabilities in Apple's store, 20 more in Google Play. Together, those apps had been downloaded nearly 500 million times. They'd generated about $122 million in revenue. And both Apple and Google weren't just hosting these apps. Their search tools, ads, and autocomplete suggestions were actively steering users toward them. So Apple cracked down on Grok, the high-profile case everyone was watching. But dozens of smaller apps doing the same thing were sitting right there in the same store, making real money for months. After the Grok scandal went public, at least 28 deepfake pornography apps were quietly removed from the App Store. 28. That pattern matters. It suggests the enforcement was reactive, driven by headlines, not by a systematic sweep. When the spotlight moves, the gaps come back. For anyone building a legal case around manipulated images, that inconsistency is a problem. For anyone whose photo could end up in one of those apps, it's the same problem. You just don't have a lawyer on retainer. Legislation is trying to catch up, but it's moving on a different clock. Wyoming passed a law making AI-generated harmful content involving minors a criminal offense. South Dakota enacted similar protections with tougher penalties. Argentina is considering prison sentences of up to 10 years for non-consensual deepfakes of minors. Those are real consequences on paper. But a criminal case takes months or years to reach a courtroom. Apple's app rejection took days. On the detection side, the tools investigators use are getting sharper. The UK Home Office ran a deepfake detection challenge in 2024. The best frameworks scored above 92% accuracy on hidden test sets, images the systems had never seen before. A separate peer-reviewed study pushed that even higher, reaching 97%. Those numbers sound strong. But detection only holds up in court if the tools that made the deepfake in the first place were subject to real safeguards before they ever reached the public. If an app had no guardrails when it generated an image, proving what's real and what's synthetic gets harder for everyone: investigators, prosecutors, and the person in the photo. Critics also point out something uncomfortable about the Grok case specifically. xAI. xAI is a high-profile company with a billionaire founder who has relationships with governments around the world. That company got a private negotiation and a second chance. A small developer might just get removed, no conversation, no letter to senators. The enforcement may be fast, but it isn't necessarily even. The real shift isn't that Apple stopped one app. It's that App Store review, a process designed to check whether your flashlight app asks for too many permissions, has become the fastest-moving enforcement mechanism against AI abuse. Faster than Congress, faster than regulators, faster than courts. So, a handful of companies that run app stores are now the front line against non-consensual deepfakes. They can act in days where laws take years. But they enforce unevenly, they react to scandals more than systems, and 500 million downloads of nudifying apps happened on their watch before anyone pulled the plug. Whether you're building a case with digital evidence or you're just someone whose photo is already online, the safety of that image now depends on a storefront review process most people have never thought about. That's the world we're in. The written version goes deeper. Links below.
Now you know something most people in this industry don't. Use it. And when you're ready to put it to work, caracomp.com. We'll see you tomorrow.